Hello everyone. We have with us today Professor Lionel Aranha, who's an authority on alternate dispute resolution mechanism. I welcome him to the show.
Thank you, Isaac.
Without doing much ado, let us go straight away to the subject. Professor, can you share a bit about your background and what led you to specialize in alternative dispute resolution?
As you are aware, I have been teaching at the Indian Institute of Management at Kozhikode for the last 27 years. Now, one of the subjects that I engage students in is called legal aspects of business. We cover all types of mercantile laws. One such law is the Contract Act. So, over a period of time, I was invited by various companies to train their workers or employees in contracts. Because the key to any good agreement being completed without any litigation is a good contract. So, I had to teach them what is a contract, what are the various clauses in a contract. If a contract is very well drafted, then there are three clauses which you have to pay close attention to. One is the roadmap for dispute resolution. Second is the jurisdiction of the courts. And third is a contract should always have certain liquidated damages, or what we call as predetermined damages. So, over a number of such lectures, my interest started developing for the roadmap for dispute resolution. And therefore, I started paying attention to it in particular. But before I had started teaching, I already had done a few arbitrations in Mangalore in the 1990s. There were a partnership going into dissolution, and then they had disputes. So, I had been appointed as an arbitrator in 2 cases. And I liked the role because you are playing facilitated to bring about a resolution to a dispute so that parties are not at loggerheads but will continue doing business with each other. They will maintain friendly relationships. That is what I always say, that you might have a problem, you might have a dispute now, but resolve it and continue to do business with each other.
So many people might not be familiar with the ADR. So how can you educate our viewers regarding the benefits and importance of the alternative dispute resolution mechanism?
See, alternate dispute resolution mechanism today includes the newly introduced mediation according to the Mediation Act of 2023 and the arbitration. It is actually Arbitration and Conciliation Act of 1996. But with the introduction of the Mediation Act, conciliation has been subsumed under mediation. See, if you look at the scenario today in India, we have about 5.5 crores of cases pending in all the courts across the country. How do we give justice to people when there is such a big backlog? So therefore, under those circumstances, government and legal authorities encourage people to find a solution or resolve the disputes without the intervention of the court, without coming to the court, independent of the courts. They say don't litigate, but resolve the dispute by appointing a third party who is amenable to you all, who is fair, who has got integrity, who is a man of character or a woman of character. Sit with them, discuss your disputes, let them resolve it for you. So that, one, you avoid going to courts and creating a logjam. Second, this method that we are talking about is cost effective, and it is also shorter in duration than going to the court. So under those circumstances, today people are encouraged to go to alternative dispute resolutions. Even if you have filed a case in the court, even the court says, please try out dispute resolution or try out Lok Adalat, which is actually a form of dispute resolution. Don't log jam the court, because if you look at 5.6 crore cases or 5.5 crore cases, you will have to recruit some 60 to 70,000 judges just to resolve that particular crisis, which is not possible.
You mean to say that for an citizen of our country, if he goes to court, getting justice is improbable within a short period of time?
Short period of time, no. It will take some time, because the methodology that is followed is of appeals. It is not that you go once and you lose everything. There is an appeal mechanism, which is necessary. But there is also this mechanism of adjournments. If the lawyer is not prepared for your case, he seeks an adjournment. If the judge has got too many cases on that day, he adjourns your case. Or if a judge has been transferred and a new judge comes in his place, he has not read your file, he will say, I will adjourn it. But these are all necessary. You can't say we will do away with adjournments or we will do away with appeals. That is not possible.
But at the same time, they could be misused and
there has been a misuse of things, but just because they have been misused by a few people doesn't mean to say that you get rid of it. So what the legal authorities and the government says is, don't come here. Try to resolve your dispute by taking the help of somebody. It may be a mediator, it may be an arbitrator, and resolve your dispute.
So now tell us, there is one more word that comes often, that is mediation, and then there is arbitration. Could you just explain to our viewers the difference between these two, and what is mediation, what is arbitration?
I will go back in time. See, when the Arbitration and Conciliation Act of 1996 was around, there were two pillars of dispute resolution. One was called arbitration, one was called conciliation. But the important thing was, conciliation is invitation driven. You have a dispute with another party, you invite him for a conciliation by mentioning the name of the conciliator. In 30 days' time, if he does not respond to your invitation, that means he does not want to conciliate. That has now been subsumed and called as mediation and is taken under Mediation Act, under the new act that was signed in September by the President. There, what the government envisages is that there would be a mediation council, there would be training for mediators, there could be an institution like the Institute of Chartered Accountants of India or Cost Accountants or Insolvency Resolution or Company Secretary, such type of an institution, from where exams will be conducted and mediators will be appointed. Now, if you have any problem, they say, try mediation before you come to the court. In the bill, 2021 bill, it was made compulsory. Before you go to the court, you have to try mediation. That is what they said. You should have a mediated agreement. But I think the Joint Parliamentary Committee was not in favor of it. So now they have not made it compulsory. If you feel you want to go for this pre-litigation mediation, you can. And you should, because the option is given to you that after 2 hearings, you can opt out. You can say, I don't want to continue. I just want to go for litigation in the court.
That is under mediation.
Under mediation. Arbitration is agreement driven. You have an agreement, very well drafted agreement. I told you in my introduction that one of the clauses which we always look at is, do you have a dispute resolution map? And that dispute resolution map is displayed in the agreement in a clause which is called the arbitration clause. You say that any dispute which arises in connection with this agreement will be resolved by arbitration.
So you preempt going to the court. So when you sign any agreement, you mention in the agreement itself,
yes,
that in case there is a dispute between you and me, we will approach an arbitrator or
yes,
an arbitration center,
yes,
so that both of us can resolve our dispute with a third party as an arbitrator and get an order and solve our issues.
Correct. Absolutely right. See, what happens is if you appoint an arbitrator on your own, both parties join together and appoint an arbitrator, we call it as ad hoc arbitration. But if you go to an institution, like if you come to the Kcci Adr Centre and say, appoint an arbitrator for us, then it is institutional arbitration. But whatever it is resolution of a dispute by a third party, and you don't get the court involved in it. So, it has got its advantages. I'm not saying that it does not have disadvantages. It has got its advantages. Like, for example, it is cost effective. It is cheaper than going to the court. It is faster, quicker. Remedies are faster. Like, for example, in Kcci Adr Centre, in one particular contested case, both the parties, we could make them get their problem resolved in 63 days. So, this is a big advantage.
Now tell us, what cannot be arbitrated? Like, can every case under the sun can be referred to arbitration, or there is any limitation of the kind of cases that can go to arbitration?
For example, criminal proceedings you cannot arbitrate. Matrimonial
divorce
cases you cannot arbitrate. Appointment of a guardian to a minor or appointment of a guardian to a disabled person, you cannot. There is no mediation.
What about a will? Now somebody has drafted a will, and can the dispute on the will go to arbitration?
No, that goes to the court.
Why in that particular case it is not brought under arbitration? Do you have any?
I don't have
any reason.
I don't have a particular reason for it, but what happens in the case of a will is it transcends into a little bit of a legal issue, because there could be this proving of undue influence and such other things. So
there could be a forged signature.
Forged signatures and all that, yeah. And also, any matter between trust and trustees and beneficiaries cannot go to the for arbitration.
What about insolvency?
No, insolvency, we have an act for it called Insolvency IBC 2016. Then we can't go for competition law, we cannot go for arbitration. But arbitration has been envisaged in the Consumer Protection Act as well. So,
can the court interfere in once you are under arbitration?
No, court only interferes for helping the arbitration process. What the arbitrator cannot do, you approach the court and ask the court to do it. Like, for example, you want property to be seized. Maybe the arbitrator does not have that much of powers to seize the property. You go to the court will say, all right, arbitration is going on. Well, fine. You want the property seized, we'll take the property. Or you want...
even a bank account can be frozen, right?
Yeah, bank account can be
frozen. The court can be requested.
Injunction can be brought. Yes, there are so many things where you can go to the court. Please remember, it's not court interference. The court is trying to help you out.
Help you, exactly.
Yes,
yeah.
Court tries to help you.
So, tell us, can you have more than one arbitrator, or is it only you can have a tribunal, or how does that work?
No, see, it's up to the parties. Many parties come to me and say, Nammadondu arbitrator agbeku. Then the other party says, Nammadondu arbitrator agbeku. That time I tell them, see, if you appoint an arbitrator, each party appoints an arbitrator, the two arbitrators have to get together and appoint a presiding arbitrator. Now, always remember, it should always be odd number of arbitrators. So, single sole arbitrator. It can't be two, it should be three. The third one is a presiding arbitrator, appointed by these two arbitrators. So, what happens then is your expenses increase, because you have to pay the fees of each arbitrator. Instead of paying a fees of a sole arbitrator, now you have to pay the fees of other arbitrator and the other arbitrator. So, it becomes a little expensive. But even if there are odd number of arbitrators, the award has to be given by the majority. If there are three arbitrators and one person says, I do not agree with this award, he will write there, I disagree, or I dissent, and he will put a signature. But the award will be carried forward because two people have agreed, two arbitrators have agreed, one person has not agreed. So we go by the majority rule.
Fair enough.
Fair, absolutely fair.
So tell us, what if one party does not attend an arbitration at all? No, though there is a clause that they have to arbitrate, he doesn't respond to any of the notices.
See, the arbitrator normally follows the natural justice, the procedure for natural justice, where you have to give a notice to the party, you have to tell what it is for, you have to tell the venue, you have to tell that you are invited for a hearing, and you can say that, you can be represented by anybody. You need not necessarily be a lawyer. You can be represented by anybody. We tell that. You can take any help from anybody. First time if it doesn't come, second time it doesn't come, third time it doesn't come, then we may have to issue a notice and say that you are not responding at all to the notices. There are some instances where I have seen they have received the notice, they have taken the notice, but they are not attending. Then we might have to go for ex parte. But when you go for ex parte, you have to satisfy afterwards, if there is an appeal to the court, that you tried all the means to get him for an arbitration.
You have to explain to the court in case he goes and say I was not involved. You have to tell them we have given him enough chances.
Yes, there is evidence. No, there is your registered post, acknowledgement due, his signatures, and nowadays what you can do is also send to his WhatsApp, and you have those 2 ticks. It is understood that he has seen it, so you can print that also.
So coming to WhatsApp, now how does technology integrate with the ADR mechanism?
No,
Can you use technology in the
Yeah,
sense, suppose somebody is in New Delhi and you are arbitrating in Bangalore, does he have to come
No,
all
we
the way
have done. Our Kcci Adr Centre has done online arbitration. Even now, we have got live cases. In 2 cases, I am doing it online. Online is I send a link either for Google or Zoom, and then they appear. They will tell me to whom the link has to be sent. It will be sent to the party and to, if they are appointed a lawyer, to the lawyer. Sometimes they say we have a legal officer in our company. He also should be present. So I send a link to all of them. And then the parties from somewhere else, like for example, sometimes it would be somebody from Udupi. He doesn't want to come to Mangalore, so I send it to him in Udupi. So I'll be sitting in Mangalore. One party will be sitting in Udupi with his lawyer and his maybe his legal officer, and another party will be sitting somewhere in Delhi, Pune, Bombay, or wherever it is. And this entire proceedings are recorded, so that later on they can't dispute and say I didn't say this, I didn't say that. Everything is recorded. But so far, I have had no issues, no problems at all. Parties, once they understand that you are there to help them to settle the issue or resolve the dispute, they will listen to you. There is always a give and take. That rigidity has to be broken first. Because first and foremost, what happens is people all have an ego. They will say that we are right.
So now, can you share a particular challenging case where ADR played a crucial role in achieving a successful outcome?
We had many such cases, absolutely many such cases. At least I remember one particular case where the amount that was due was 1 crore 50 lakhs. And the person started with, I'll pay 5 lakhs. And denying that all the service had been provided, all the parts, the goods, the merchandise has been sent to him. Everything he denied, absolutely denied. In fact, what he did was he also brought political pressure. He made the minister of a particular ministry to talk to me because he is related and look after him and all that. But somehow I managed to convince him and that he has to pay at least the cost of the products. Forget about the profit part, plus the GST that he has benefited, because there is an input tax credit. So that input tax credit he has taken. Now he is denying that there are any, he has not taken any product and all that. So all that put together, it took quite some time. It took about nearly 78 to 90 days. And then he agreed to pay. Now when he agreed to pay a certain sum of money. But when it came to signing the terms of reference for the purpose of putting an agreement out, he said that he will pay in installments.
But you allowed that?
Then the opposite party said, you have to pay me, give me checks. He refused to give checks. Then on the basis of my credibility, I said that I will stand as a guarantor that he is going to pay. Definitely he is going to pay. He has got it in him that he is going to pay. He agreed. But instead of nearly 12 months, it took 18 months.
But he resolved it.
He resolved it, and the sad part of it is about 2-3 months after he resolved it, he committed suicide. That for me is a very difficult case because I had grown close to the man, and all of us, after the initial tutu meme, for 5 minutes we used to have some jokes, we used to laugh, and we used to. But in those days, I remember him telling me that he's going through a very bad phase. In fact, one day on camera, and this was online, we were going online, and he wept. So we
You
couldn't.
mean to say he was quite a popular known figure?
A very well known figure, very nice person also, but somehow I think he couldn't handle his finances properly.
What industry was he in?
He was into film industry.
Okay.
And
So that really shows that he was sincere to pay the money. But
see, because he was sincere, I could make out his sincerity. I said that we'll give him a chance. I did not insist on, checks and all that. I said that, okay, we'll take him by his word. And he stood by his word. I still have his last message that he sent to me, that after he had paid everything, he said, Aranha Saab, whenever you come to Bombay, just look me up. I would like to sit and have, discuss with you certain matters. But that was not to be. After a few months, he committed suicide.
Very sad to hear that.
Yeah.
Professor, could you tell us on what basis the court can set aside a judgment given by an arbitrator, an order? I mean, when you use arbitration, I think you call it an order, right?
Yeah, no, it's an award.
Award.
See, what happens is the award can be challenged within 3 months, the 90 days. But the grounds for challenging the award are very, very less. Like, for example, if you can prove to the satisfaction of the court that this particular award has been brought about because of fraud or because of corruption, or the arbitrator has not followed the principles of natural justice, or the award contravenes any law of the country, or the terms of reference that were given to the arbitrator were one, but he has gone and ruled on something else, which is not within the scope of arbitration. So there are these cases only where you can say that I want to set aside the award. Usually, the courts should not interfere in the award given by the arbitrator. They should not read the mind of the arbitrator. They are not sitting on an appeal and going into the case all over again. But unfortunately, in some cases, they have done just that. So that is a bit disappointing. But otherwise, as soon as 90 days pass, the award becomes a judgment decree. If there is no challenge.
How do you feel that the legal fraternity can be, brought to better understand the ADR mechanism if they are interfering, as you said?
No, see, when I talk about legal fraternity, there are two things. One is, let's say, the lawyers first. Many of the lawyers are, particularly the younger lawyers, are all for ADR. Because they believe that this is where their profession lies.
The future lies.
The entire profession, they want it to be oriented towards settling of disputes rather than taking it to courts. There are some lawyers of the old school of thought who say that the arbitration is of no use. Ultimately, what you will get is an award, and this is the award. If it is not going to be enforced, you will be only having a paper decree.
But that happens even in a legal judgment, right?
That also happens in a judgment. Sometimes you can't enforce the judgment. So under those circumstances, they say, Hogbedi, yen prajanilla. Particularly, they say this when the party is not, one party is of, say, local origin, the other party is not of a local origin. Then getting the award enforced in that particular person's domicile becomes very difficult. Like, for example, I know one particular case where the award was given, the party was from Delhi. So by the time 3 months passed and it became a decree, and this party from Mangalore had to go to Delhi and enforce it, the city had swallowed the person. He was not to be found.
Oh, he went incognito.
Completely. But then somehow, there was a very brilliant lady lawyer who traced his properties. Somehow, hats off to her. She took a lot of trouble and presented it to the court, and the court said attach the properties. But it took a while, and it took a lot of time, energy, and money also.
I think we have not spoken about the fees. We are supposed to, as a person approach the arbitrator. What are the fees? And also tell us, where can an arbitration be conducted? Is there any hard and fast rule you have to do it at XYZ place, or it can be conducted anywhere at your convenience? And does it mimic the court, or it goes more informally? Just could you brief our viewers?
Absolutely. See, about mimicking the court, it all depends on the arbitrator. If I am an arbitrator, I don't allow, as far as possible. I don't encourage mimicking the court. I like to make people very comfortable. Like in the Kcci Adr Centre, when they come, our staff is very well trained that as soon as people come and assemble for the case, they come in and ask them, do you want a coffee, a tea, or lemon tea, or we have also got arecanut tea. We ask. Biscuits are served. The latest edition is banana chips. So even that is served. So this makes the people a little taken aback. They say, "Idu entadri, illi bandu ನಾವು ಚಾ ಕುಡಿತೇವೆ ಇದು ಏನು?" Then
it breaks
actually
that seriousness.
It is an icebreaker.
They come icebreaker.
So what happens is people start discussing. I remember once, for about 15 minutes I did not talk. I was actually working on something. Then they themselves opened up. And there are parties who are at loggerheads with each other. They started talking about the weather. They talked about the paucity of rain. Then they started talking about the business. The lawyers started talking about each other. Then I said, all right, let's start. And within about 1 hour and 15 minutes, they had reached some semblance of an agreement.
That's nice.
Yeah. So I feel we are doing we are not mimicking the court. Now, coming to fees, you were the founder of the ADR Centre. We all joined together. And what did we say? We said that we are going to give service to the community, the business community. So we had drastically reduced the fees. In the Act, there is a Schedule 4. The Schedule 4, minimum fees of 45,000, maximum of 30 lakhs. But it is not mandatory. They are there in Schedule 4, the fees are there. We have reduced it by 50%, but then we have reduced further by 50%, and then there are people who come to us and tell us, we have done free, you know that. I had one particular person who actually kept last that, pledge slip of the bank where he had pledged his gold. And he said, ನಾನು ಹೇಗೆ ಯಾವುದು ಫೀಸ್ ಕೊಡಲಿ? ಸೊ you remember we had a meeting and we decided that with these 3 people we will not charge them anything. We did it free. So where it is possible to take some amount of money, we do take, because it is time and energy of somebody, so somebody has to be paid. But ours is very, very less fees. But taking that into consideration, I would not say that other people are following the Schedule 4. See, I've come across cases where the arbitrator has charged separate fees for reading. He's charged separate fees for sitting. He's charged separate fees for writing the award. He's charged fees for traveling. So that is there. There is a small bit of a scam there when we talk about the fees. But we try to, as far as possible, see that people are given resolve a dispute. If they are capable of paying, then they should pay. If they're not capable of paying our discounted fees, then we say, all right, fine, we'll make an exception to the rule.
Now, the US is one country where the legal system and the people are very aggressive in going for redressal to the legal system. How do you compare ADR happening in US and in India? How's the legal system? Could you just give us a brief
No, here what has
idea?
happened is we have, I think we should blame ourselves. We have failed to educate the public. Now we started in 2020, isn't it? This will be the 4th year. March, it will be 4 years since we started it. We do small programs. Like I myself have gone and done a program for the Contractors Association. I have done a program for the Canara Industries Association. I have done for MSEZ. There's scope for doing it for a lot of other people as well. So if any association invites us for a talk for half an hour, we are willing to go and talk to them. Because the whole idea is to make people aware that we have such type of a center here in Mangalore, and you can resolve your dispute. And please remember, when you resolve the disputes in this particular manner, it is not adversarial. You are not fighting with each other. You are just appointing a person called an arbitrator who will collaborate with you and try to get you a solution. Sometimes the solutions could be creative, which the court may not be able to do that. You get it? So that's sort of we need to encourage people. People once they're aware, see, in America, as you said, awareness among people is more. That's why law of torts thrives in America, but here law of torts doesn't thrive because people don't know about it. So under those circumstances, it's only education, education, and education.
Now, suppose somebody wants to pursue a career in ADR, being arbitrator. What is your advice for them, and what are the skills, basic skills anyone should possess to be an arbitrator?
See, in the Act, you don't find any qualifications. Qualifications were introduced and then they were removed. Today, anybody can become an arbitrator, but let me tell you, when you select an arbitrator, first see his level of knowledge on the subject at hand. I'm not saying, he should know the law, but he should know the subject which is being dealt in the dispute. If it is accountancy, then the accountant. If it is something to do with the construction, maybe the person should have some basic knowledge of construction. If it is ships and shipbuilding, then somebody who knows about marine technology. If it is about contracts, anybody, because contract is common sense. So you require to have a person, a lady or a gentleman, who is fair, who is neutral, who is impartial, who can draft an award. This is very important because today an award has to be given and the reasons have to be stated. In the erstwhile 1940 Act, you could simply give one line as an award. Then they had to take it to the court and make it into a decree. Now it's not like that. Now you give a reason. After some time, the award itself becomes a decree by passage of time. So a person who can draft, a person who can write the award in language which means one thing and one thing alone, does not give two connotations. Such type of a person you have to select. And as you know, Kcci is willing to train people. We are actually in talks the other day, if you recall, we wanted a knowledge center, and in the knowledge center, one of the things that we were thinking about is training people in contracts, training people in arbitration. In fact, the IIM where I teach, they want me to conduct a course, an online course to train arbitrators. Now, I have said put it on hold because we'll do arbitrators and mediators. Let us see what the government is envisaging for training of mediators. As soon as it becomes very clear, we may launch a course.
So that clarity on what is a qualification for a mediator is not yet
notified.
You mean to say that there could be a specialized institute?
Yeah, I think there would be a specialized institute and then there would be an exam. That is for mediators. For arbitrators, they have not. So far, nothing has been envisaged. Anybody can become an arbitrator. That is the beauty of it. Somebody whom you rely on. Somebody whom you feel can resolve the dispute. Somebody who can be just. That is important.
So, would you brief our viewers on how the landscape of alternative dispute resolution has evolved over a period, and what are the trends for the future? And do you see a bright future for this mechanism, or do you feel that still a lot of things have to be done by the government or the policy makers?
No, government has done enough. All the time we cannot fall back on the government. Government has taken steps. Like for example, constantly they have been updating the Arbitration and Conciliation Act. Now they have brought in the Mediation Act. It is for the people to understand that they are required to go elsewhere rather than the court. So I feel, taking our own example, we started with 0. Today we have successfully settled 20 disputes. We are now handling 12 live issues, which makes it about, in say 4 years, about 34 cases, which is a feather in our cap. But as more and more people become aware, as more and more people become satisfied with the decisions which are given or the award that is given, as more and more people come to know that this is easy, as more and more people say that we are not being pushed into litigation, they will come. And I feel that as time goes by, we will have more and more disputes coming away.
So could you tell us what are the key challenges that you've faced over a period of these 20 cases that you resolved?
No, 20 cases, these came from the MSMED. So they were a little bit of they were litigious cases. But I've also done cases which have not come from MSA. It's family disputes, partnerships, family businesses they're having been disputes and all that. One challenge that I always have is that the party who feels that he has lost just doesn't, he feels that you have done injustice to him. And he goes around telling a lot of, like how people are. They'll open up, they'll start talking and all that. But I always tell them, go back, read, see what you said, see what you did, and what is it? Many people have come back after some time and told that we are very sorry that we had hard feelings and all that, but now everything is sorted out. So we are happy. But one person from 1990 till now has still kept it in his mind. Every time I meet him, he says, no, you didn't do justice to me. So those one or two cases, see, that we can't do anything. All fingers are not the same. But it is satisfying at the end of the day that you have played a role in settling disputes of parties. So today there's one particular family, I can't mention them on television, on YouTube, but for all their functions, without, irrespective of whether it is a function which has got joy or whether it is sorrow, they always come to my house personally to invite me. Even to this day, even after nearly 20-25 years. So I've gone for all their weddings, I've gone for all their baptism, your Graha Pravesha, I've gone for their thread ceremony, I've gone for everything. It is like I feel that they are part of my family.
Now, as a businessman, if on the we do a lot of bills to our to whom we get purchase order. On the reverse side of the bill, if I mention that any dispute on this bill should go to arbitration, is it valid?
It should be valid, but one or two courts have said it is not valid. But I feel that it is valid. Only thing is that what you should do is you should draw the attention of the person to this particular clause which is there in the reverse of the bill. Because sometimes what happens, people will say, I didn't see the reverse of the bill. You're not known to look at the reverse of the bill.
Yes.
So somewhere you have to put
on the front side of the
front side, terms and conditions apply, and the back you put the terms and conditions. If there is a dispute regarding this particular bill, we will go to the arbitration center. Fine, perfectly all right. Like there was one particular person, a lady entrepreneur, who came to me and told me, I want to put it in my bill. So I drafted it and gave it to her. Then she made it compulsory that it appears in her bill. After some time when I met her, she said, what? I lost about 5% of my business because of that. Then I was surprised. I looked at her. Then she says, no, see, why I'm saying that I lost 5% is that 5% which I would have otherwise lost because they would not have paid are not coming. So my recovery now is 99.9%. So I had a little bit of a,
You're taken aback.
But then
she explained it in a better words.
Yeah. So one of our own members.
Yeah.
Yes.
So thank you very much, Professor Lionel Aranha, and we wish you all the best in your mission to promote the alternative dispute resolution among our community and in our country. Thank you very much.
Thank you very much, Mr. Vas, and thanks to Kcci. Wish you all very best, and thank you for having me.